Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.
It's got to be a dual effort on the part of both Idaho Power and this office, as well as the Attorney General, to try to cool the waters, and that'll be my role as governor.
Idaho Governor John Evans, Attorney General Jim Jones, and Idaho Power Company Board Chairman James Bruce continue their negotiations over the Swan Falls water rights controversy. We'll have an update tonight. Good evening. Negotiations resumed yesterday among Idaho Governor John Evans, Attorney General Jim Jones, and Idaho Power Company in the continuing effort to settle out of court the Swan Falls water rights controversy. But the ultimate success of those negotiations would seem to be in doubt, in no small part because of a new round of verbal sparring among the principals. Yesterday, Attorney General Jones and Power Company Board Chairman Jim Bruce, prior to the resuming of the negotiations, accused each other of not negotiating in good faith. And the Attorney General vigorously denied charges yesterday made by Republican State Senator Reed Budge of Soda Springs that he, Jones, has a conflict of interest in the Swan Falls case. The verbal flack seems to have thinned out a little bit today, at least on the part of Power Company Board Chairman Jim Bruce. We'll hear his assessment of the Swan Falls situation in a moment. And later, the Attorney General Jim Jones will discuss the situation from his perspective. We'll also hear tonight from two state senators, John Peavy of Cary and Bill Ringert of Boise, two legislators who have been on opposite sides of the Swan Falls issue in the state legislature. We invited Jim Bruce to appear on this broadcast as well tonight. He declined our invitation, but did speak on tape with producer Gary Richardson earlier today. Richardson asked him how the Swan Falls negotiations are going.
I think we're making headway. You're talking about a very complex subject, many problems, but I feel that all parties have entered into it with an intention of trying to see a possibility of a compromise settlement, and I really believe that if we're able to do that, that will certainly be best for everybody in the state of Idaho.
Do you really feel you're any closer today than you were a week ago?
Well, I believe so, yes. I think that the governor is certainly very desirous of attempting to arrive at a compromise solution. I know I am.
In the past week, there's been a great deal of emotional rhetoric surrounding this issue. How do you think that affects the negotiations?
Well, I don't think it helps any. Emotional rhetoric is always, it has a tendency to kind of polarize things, and when that happens, why it's really difficult to get a compromise settlement. In the course of litigation, why it may be all right, because in litigation you have two sides, and you do the best you can with respect to your particular side. But if you're trying to make a compromise settlement, why it has difficulty. It creates difficulty.
Can you give us some idea of what the parameters are within which you're working towards this compromise?
Well, we're trying to come up with some solution so that there will be a reasonable amount of water in the river we talk about hydroelectric generation, but there's a lot more than that. You appreciate that the river flow, sure, it has hydro generation, which enables us to have the low hydro rates that we have, and that's very important. But also that river is a working river, and when I say a working river, you can't take all the water out of it upstream and have it working downstream for many other things, such as hydroelectric generation, but also down below our Hells Canyon project, for example, we have the anadromous fish runs, and Idaho Power Company, the federal government, the state of Idaho, state of Oregon, state of Washington, all have put an untold amount of money into trying to replace those anadromous fish runs. And if you don't have any water there, bingo, you don't have any fish. That's what we'd have to think of all facets of that and try to figure out where we're going and protect and have at least the kind of a flow that will enable that to happen. as far as upstream development for irrigation, irrigated agriculture, this is what we have to do. We have to come to some kind of and that's part of the parameter, trying to define some limits. Actually, if you don't have any limits on it, there's more land up there than there is water.
Is an increase in the minimum flow a likely point of compromise in this issue?
We think so. We think so. We hope that might be, and that's one of the things we've been talking about.
Any idea where you might?
No, we
settle
didn't.
on?
We didn't come to any determination on that. But we're not talking about as far as Idaho Power Company is concerned, we're not talking about a massive flow, say a minimum flow of 10,000 second feet. We're not talking about that. The state water plan right now says 3,300 second feet. We feel that's too low. That's below the historical flow, substantially below the historical flow on a daily average. We think that you should look at the historical flow on a daily average and maybe use that at least as the guide stone.
The Attorney General said that he thinks you're negotiating in good faith, but he has some question about whether the company is unified behind you.
Oh, I think they are. I think obviously whenever you have a company, whenever you have anything, you have people with different opinions and different thoughts. But since I've been chief executive officer of the company, I've tried to. I have staff meetings. I discuss with the company. I discuss with our board of directors because that's really I work for the board of directors basically, and we have discussed. You'll have different ideas. Obviously, you have different ideas. Anybody does, and we don't always think with one mind. But I think basically I make the subject to the advice and control and discretion of the board of directors. I'm the one that has to make the final decision. This is where the buck stops, and I don't think we're speaking with different voices. We may have different ideas sometimes.
One final comment. Jones, excuse me, kind of attacked your argument that you're operating in the best interest of the ratepayers by saying that by advancing a contract that would deprive ratepayers of some kind of relief, you obviously can't be operating in their best behalf. What's your response to that?
Well, I think those people that we're talking about basically most of them are already incurred expense and money and are utilizing and are pumping water and are utilizing it. Now, theoretically, in the pure quill, that's we could maybe you could make that argument, but practically, why? You know, we know what that is. We know how much it is. And why should we try to take away from those people where they've spent a lot of money and they've gone ahead with something? And that was from, you know, we filed that lawsuit in '76 and it was '82 before anything happened. And nobody knew what the decision of the Supreme Court was going to be. So those people were in good faith. And you know, it's just fairness and equity as far as I'm concerned.
That interview was videotaped earlier today. We turn now to the views of Idaho's Attorney General, Jim Jones. Mr. Jones, you heard Mr. Bruce say that how he thinks the negotiations are going. What's your view of that?
I think so far the negotiations have been going better than I expected. We worked up a tentative negotiation agenda, and quite frankly, I was surprised that the items that we thought were appropriate to be talking about and the range that we thought might be agreeable from the standpoint of protecting the people in the state were not all that far apart. So I was pleased with that. I think the question is whether each party is operating in good faith and whether each party is able down the road to deliver. Idaho Power, by getting the support from the other officers and the board of directors, and of course the state in getting the support of the legislature and the State Water Board. But I think that we are on the right track by having talks. I think that there's more common ground than maybe would be expected, and so I'm cautiously optimistic.
But I take it you have some substantial concern about whether the company will be able to deliver.
I just have a feeling that there is a split in feeling amongst the people in the company. I have been informed, and of course I don't have any hard and firm facts to back it up, but I've heard from people who are in a position to know that there is a substantial split in the company ranks as to whether they ought to go ahead and negotiate and what the parameters are. You know, it could be such a thing that, and I think that Jim Bruce is in good faith in trying to work out a situation, but he's not going to be there forever. And as I understand it, he'll probably be leaving the company in the next year or so, and again, I don't, that's what he had seemed to indicate. If he is in that position, any long-term negotiations could be subject to radical change, because right behind him you have what I consider to be a fairly hard liner, and that is Logan Lanham. So it just depends on whether they're able to speak at this point with one voice. If they are, and if Mr. Bruce is correct, then I hold out some hope. If not, I think that there could be some problems, and I'd hate to raise false hopes among the people who are depending on what the outcome of this is.
I hear you. I should say maybe that Logan Lanham is the vice president of the company who, at least in the legislature, has been sort of the point man on this particular issue. Is it possible to reach an agreement in this climate that's developed over the last few days of you raising this question? You heard Mr. Bruce respond to it. Others have responded to it as well. The accusations about your conflict of interest alleged by Senator Budge. Does all of that just muddy the water? Pardon the expression, but does it make it more difficult to reach an agreement?
Well, it certainly doesn't help anything. The charges that Budge made, I think, fell of their own weight, but they were some of the same old worn-out, hackneyed charges that, again, Mr. Lanham, the chief lobbyist for the company, was making way back in the legislative session. It doesn't help anything. The new massive advertising campaign that I consider to be deceitful and half-truth oriented doesn't help anything. We had all hoped, and we discussed it yesterday, of lowering the profile of the public debate. And apparently the company is making some gains with its advertising campaign and isn't willing at this time to call an end to that large debate that they are carrying out in the newspaper and radio and TV.
How is, I brought along the latest, I thought you might raise the question, I brought along the latest ad as it appeared in the Idaho Statesman. I think the same ad has appeared in most of the major papers in the state. How is it deceitful?
Well, it assumes that Idaho Power had never agreed to subordination of their water rights on the Snake River, which is just absolutely not true. Time and time again, power company officials, including Tom Roach, and I think Tom would be very disappointed with the course that the power company is taking. Tom Roach testified that they had subordinated their rights on the Snake River. That appears in testimony before the House Interior and Insular Affairs Committee back in 1952, and also in numerous statements made before the Federal Power Commission. We just turned up some.
But just in a nutshell, this ad goes to your concern about whether the company is really operating in good faith.
It does to a large extent. You know, if they're fighting out there on the publicity battlefield and dumping thousands of dollars into it with an obvious intent to influence public opinion, which in turn would influence the outcome of some of the elections, you know, you kind of have some questions in the back of your mind. They talk about a $54 million rate increase. There's no credible evidence that can be supported to say that that would occur. And it doesn't take into account the fact that the governor and I have proposed legislation that would make it more difficult to get a water permit in the future. And it doesn't take into account that the State Water Board, with the support of the governor and the Department of Water Resources and myself, are going to be initiating new rules and regulations to make it more difficult to get a water license.
Well, let me just ask you finally, and we'll come back to some of these points, I'm sure. You said you were cautiously optimistic a moment ago, but I think I'm hearing a string of reasons why these negotiations are not likely to be very successful.
Well, I think you have to look at the negotiating strategy. Idaho Power Company is used to having its way in this state. They're probably the most powerful entity as far as lobbying with the legislature. They're darn good at it. And on any issue where they have had a lot of money riding on it, and they have hundreds of millions of dollars in revenues riding on this, they've taken a fairly hard sell advertising approach. There was a massive advertising campaign back in the 1950s over the Hells Canyon controversy. And to an extent, I think that you have to look at the psychology of the company. In the past, it has been negotiating from a position of strength. That doesn't mean that they may not be negotiating in good faith, but it's kind of like the battle for Pork Chop Hill. You sit down at the negotiating table and try to grab as much territory as you can so that your position is as good as it can be as you get into the negotiations. And I think there's a certain element of that.
We'll come back, sir. Thank you. If these negotiations among the governor, the Attorney General, and Idaho Power Company do result in some sort of agreement, the Idaho legislature will have to sign off on that deal. Two key players in that situation are State Senators John Peevey and Bill Ringert. Both serve on the Senate Resources Committee, and both have been deeply involved in this controversy for a long time. Senator Peevey, let me ask you, in this climate, are these negotiations going anywhere?
Well, I certainly haven't been on the inside of the negotiations. I certainly hope they do. I think the governor's relying on some very bad legal advice from our Attorney General. I think that the problem is far, far greater than Mr. Jones lets on. It isn't the future applications and permits that we're worried about. There are far more applications and paperwork already done, already started, than there is water by over 2 times. And it's not a matter of just a $54 million rate increase. That study that we used that he referred to is the most generous one that I have seen as far as the being favorable to the subordination crowd or the development crowd. There's only 4,500 cubic feet a second left in the river in the dry years in the low month. This study only depleted the July flow 171 cubic feet a second, and yet there are over 10,000 requests for over 10,400 CFS out of that river. Now, how are we going to sit here in 1984 and 1985 and talk about a new minimum stream flow law that will predate those 1976 and 1977 applications? What I'm saying is that I think if the subordination crowd wins and Mr. Jones wins and he convinces the governor to stay where he is on this issue, that all the water will basically be gone. All the water that's available for new development is finished. All the paperwork's been started.
So
and this talk about our grandchildren is pure, just pure bunk.
So you're saying, if I understand you correctly, that the Attorney General and the governor are coming at this from entirely the wrong point of view, even if you concede that they have a different point of view than you do.
Well, I think that the governor's relying on Mr. Jones' advice, and I sure wish he could get a second opinion. The state has lost control of the water because of the administration over there in Department of Water Resources has just printed those permits and those applications like the federal government prints money.
Okay, let me just interrupt here and get Senator Ringert's comments on this. How do you see this situation as we sit here tonight, Senator?
I don't, as is the case with Senator Peevey, I have not been privy to the negotiations, so I don't know what their goals are or even what they've perhaps agreed upon in a preliminary fashion. I think there's a limitation on what can be settled by negotiation. We have constitutional restraints that have to be observed. My thrust in the 1983 session was to give a full test to the constitutional power to subordinate. When the amendments came up this year, my thrust was to limit subordination to post-1929 situations. Frankly, I don't think the legislature is of a mood to do anything to subordinate Idaho Power Company's existing power generation rights. If the negotiations are directed to some solution to the future application of Idaho water to a variety of beneficial uses, then I think they might get somewhere. I think if subordination comes up again in the legislature, it should be directed to a resolution of problems of the future, and I think I disagree with Senator Peavy on existing applications, because I believe that our Supreme Court already has held that new legislation can affect existing applications, perhaps even existing permits. I think we can obtain a legislative solution to problems that arise because of existing applications. My principal concern is that we do not, I have two really. One, that we do not inalterably lock up the total resources of the Snake River by some power applications, such as some of the cogeneration applications that are already in existence, and thereby preclude ourselves from an intelligent application of that resource to its most beneficial use. And secondly, that we do not rush into a wholesale revision of the appropriation process, such as I viewed Senator Peavy's amendments to this year's subordination bill, and foul up our entire appropriation process while trying to solve some of our Swan Falls problems. I think they need to be separated and should be separated.
Well, gentlemen, I'm going to open it up here, and with three shades of differing opinion here, let you debate some of these points. First, Mr. Jones, Senator Peavy seems to be saying, I think if I understand him correctly, that some of your basic premises and the advice you're giving the governor is just way off mark.
Well, the governor is listening to us, and he's also listening to his own counsel, and he's listening to the people on his advisory committee. And I think they and I and Idaho Power have all said the same thing, and we all differ from Senator Peavy. We all agree that there's water there available in the river for additional upstream development of industry, agriculture, and communities.
And that's where changing this minimum flow could come into some compromise.
Certainly. There's enough water to accommodate that and also maintain a strong hydropower base that will be beneficial to new industries and new agricultural development.
And Senator, you just don't agree with that?
Oh, I think there's water available, Mark, but I don't think it's proper for the state of Idaho to resort to dictatorial policies and confiscate someone's property, use the police powers of the state of Idaho to take someone's personal property that thousands of customers are relying on for cheap electricity and take it without compensation. I think those are tactics that one would find in Nazi Germany or communist Russia, and I don't think they have any place in the state of Idaho.
But of course, Senator Peavy voted for a resolution in the 1983 legislature that asked the senators and congressmen back in Washington to request FERC to do just that very same thing. So I think you have to...
Federal Energy Regulatory Commission.
Right. You have to look at what the police power is. It's the power that the state has to regulate the general welfare of the state. Of course, we're contending that Idaho Power doesn't have any rights because they made a deal back in the 1950s, and of course this is a matter that's going to have to go through the courts, but they made a deal back in the 1950s, and it was memorialized by statements from Tom Roach and Len Jordan to the effect that they were subordinating. Some of that evidence has not been presented to the courts yet, and it will be.
Senator?
Well, I think that you know what happened 8-10 years ago is what Mr. Jones is saying is true. The power company did believe that they did not have defense against new applications for that water, and it's only because a group of customers concerned about the escalating cost of electricity went to the PUC and filed this complaint. And then they discovered through a Supreme Court decision that they did have defensible water rights, and they have not given them up. So this argument about what they thought then is really irrelevant. What you have to do is get that Supreme Court to reverse itself, or a higher court to reverse that Supreme Court. Now, the reason that the power company was for getting rid of the river back in the old days, in the mid-70s, was that it made them more money that way. They were the only way a monopoly, like a utility, can make more money, like Idaho Power, is to expand the market for electricity. And they viewed the river as a market. They got to provide the electricity to pump the water away from the river, as well as provide the facilities to replacing energy that you were taking away from the river because the river flows were dropping. So they were, you know, just operating on a profit principle back in the old days.
Senator Ringer?
Well, I think part of that question is going to be resolved in the courts in one of the 3 cases that are now pending involving the Snake River. There are some water attorneys who take the position that the 1929 amendment has already subordinated Idaho Power Company's water rights, at least those that were established after the effective date of that amendment. That is a matter for the court to determine. As I said earlier, I seriously doubt that the legislature is now going to, by legislation, subordinate any of Idaho Power Company's existing water rights. I just don't think the mood is there. The general public apparently does not have heavy support for that route.
Well, let me see if I can get some agreement on that. Do you buy that?
Basically, you know, that isn't one of my major concerns. My major concern is that the public out there thinks this is a squabble between the farmers and Idaho Power. And the people watching this program who heat their water, heat their homes, cool their homes, or watching television with electricity have an enormous stake in this. And they should let the Attorney General know and the Governor know that they would like to have this thing settled, and they don't want to pay a lot higher electrical rates, which is what we're talking about. Now, I don't think those advertisements are all that deceitful. I think that the company would be really negligent in their duty to their customers if they weren't pointing this out.
Well,
Yes, sir.
let me address one point on that. I haven't followed the advertisements that closely, but I think they are implying that the Swan Falls water rights issue has been resolved by the Supreme Court's decision. That is not the case. The only thing that was resolved by the Supreme Court was their determination that the Hells Canyon licenses did not in and of themselves subordinate the Swan Falls water rights. That case has been sent back to the district court for the resolution of the many, many issues that remain to be determined.
So you would agree, at least to some degree, with the Attorney General that the ads are deceptive?
Well, I'm not going to say they're deceptive, Mark, but in my view, they do not tell the entire picture.
Okay. Mr. Jones has said, Senator, that I believe that you're even looking into whether there might be some violation of the Sunshine Law as a result of the placement of some of these ads, right?
There were a lot of complaints when the, excuse me, the advertising campaign started 12 days before the primary election.
And
so,
I'm sorry, I'm just about out of time, but you are looking at...
We're looking into that, not for the possibility of pursuing a criminal charge, but to see what the nature and extent of that advertising campaign is and to see whether it's in violation of some of the civil portions of the Sunshine Act.
Is that appropriate, Senator, as one of the architects of the law?
Having written the Sunshine Act, I don't think that the advertisements were covered. They were not in support or in opposition to any candidate or any statewide issue that was going to be on the ballot.
Okay.
It's someone's exercising their first constitutional right of expression.
Got to leave it there, gentlemen. I think your discussion indicates the difficulty surrounding this issue. Senator Peavy, Senator Ringert, Mr. Jones, thank you for joining us tonight. We'll be back tomorrow. I'm Mark Johnson. Good night.
Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.